I will tell Mr Maidmen you're here because we might start early. Mr Maidmen has arrived, so he's actually in the room, so we'll go in.
Box of puppies.
Now you didn't, I'm not going to wear a mask, you didn't have to have a mask.
Got one if need to.
There is some hand sanitiser on the table and there is some water and cups and
Fantastic. Cheers, Sam. Oh, sorry. Fine one. Is it here, is it?
No, here.
Oh, thank you.
And
Keen.
King.
Is it keen to do things? All right, thank you. Morning, sir. How are you?
Mr Murphy, is it? Yes, good morning, Mr Murphy. How are you today?
Pleasure to meet you, sir.
And who do you have with you today?
My name's Mark Keane. I'm just a support person here.
Mr Keane. Mr Keane, how are you today?
I'm box of fluffy
Good.
ducks as always, sir.
Mr Keane, thank you for coming today. I'm just going to explain to you the process for a support person in this particular jurisdiction. This is not a court. The proceedings in the LCRO jurisdiction are presumptively private, but I'm happy for a party to have a support person with them. But just to emphasise to you, the support person can play no part in the proceedings, can't say anything, can't take notes, and of course the proceedings are confidential.
Of course.
So that's
No problem.
just to emphasise that.
Pretty much like a Mackenzie friend, but just don't get to help in any way.
It's sort of a little different to a Mackenzie friend in that a Mackenzie friend may be called on to assist at times. In this jurisdiction, it's very much...
Yeah, but it's mainly because John's diabetic and he just
Sure.
doesn't like to be by himself. So.
No, happy for you to be here and thank you for that.
Thank you.
Mr Murphy, I'll start as I normally do by just briefly explaining how these hearings work. And a little bit about the jurisdiction which will hopefully assist you. The LCRO process is a process of review. It's not an appeal. It's not a de novo hearing. By that I mean it doesn't start and look at new issues or anything like that. It's very focused, as the word suggests, on review. A standards committee of around 12 people have looked at your complaint, have given a decision, and you have exercised your right to review that decision. So you're saying to the LCRO, I disagree with this committee's decision. So the focus for you today really is to take me through why you disagree with the committee's decision, what points of objection you raise to it. It's now pretty well accepted that the LCRO process is an inquisitorial process rather than adversarial. And by that it means that the review officer will ask the parties questions. Sometimes that questioning may be robust because it's the obligation of the review officer to put the party who's taking the review to the test, to flesh out their case. If I put you to the test, if I ask you questions robustly, if I stretch your questions, please be assured that's not a reflection of any indication of you having been formed about your particular case. Rather, it's meeting my obligations to the role to the review officer when they have that inquisitorial function. But in general, my approach is this. I prefer to, first of all, my objective is to ensure that you have an opportunity to tell me what your case is about today. So my approach generally is to start with you and give you an opportunity to take me through what your concerns are. And I will tend to ask you any questions generally at the end if I have any thoughts about it. This is an applicant-only hearing, so I don't have the lawyer present today. My final instructions when I have two parties or more before me is that this office is not meant to be cluttered with a lot of legal rules or technicalities. We're here to hear the parties' stories. The only rule that I am insistent on with lawyers, clients, is the rule of courtesy. Is that there is courtesy in putting their positions and responding to them. That's the fundamental rule which I apply in my hearings, because that ensures that everybody gets a chance to be heard. All right, Mr. Murphy, is there any questions about the process before we start?
No, Mr. Chair, I just want to keep it simple from a layman's point of view on this matter. My background is I have had rather a tarnished ride with solicitors over the last 15 years. So I'm probably no fan of the legal profession. So far today, I would like to thank you for your approach. I feel like you've explained the situation to me, and whatever the outcome is, I guess I'll respect your outcome. But the fundamentals that I've got is that I have been quite annoyed in the last 20 years with the legal profession. No less, I won't go on for long, but if you give me 3 minutes...
No, Mr. Murphy, let me just get you right at the start. I'm here to hear your story.
Yeah.
I've got the morning.
Yeah.
Take your time.
Okay.
You take me through what you want to tell me.
Okay.
I'm not going to get disinterested or...
Okay, since 2007, I've had conflict with the legal profession, and I've been very adverse towards it. It started when I met up with Tana Iri, and there was a police investigation started, which I was involved in, and it blew up into, that brought me very close to Maori, particularly Tūhoe, and I began to side with the Matap as to their inflictions that they've released over that sign that you sit underneath. I didn't want to get into any sort of banter with them or any sort of conflict with siding with them, as I run businesses. And I've been brought up in the Catholic faith. I've always lived in Auckland, and I've always used, at that point I used Foley and Hughes as my lawyers. They did all my property transactions and all my legal things. And I had a business partner at the time who I was with business with for 15 years, 20 years, and that fell apart. And then these lawyers and accountants that I thought were going to be loyal to me, that had a judicial duty to my interests, they really turned on me. They stuck up for him, and what happened was I was just left at the side of the road. The Digitech tax deal came along in 2009, and one lawyer, poor Dale, was acting for me in my company affairs, and then he was acting for my partner at the time, who was suing me. And he had all my financials, he had all my legal things, he had everything about my life in his office, both Foley and Hughes and Paul Dale. Documents, mortgages were getting signed and PPSRs were getting put on things, and I really suffered from consternation at that point. I tell you, I did not know what to do. There were certain gamblers that they put onto me. They set me up. It was just a horrible, horrible situation. So yeah, I teamed up with Tani at that stage, and I went down there and stayed with him for 6 months in Rotorua. Got close to Maori. And he was going through his problems with the Crown. An investigation was started, and I was part of that investigation. I was approached by police, high-level policemen. They wanted me to become an informant. I wouldn't talk to them. And because I did that, of course, I was ostracised to the bad man side.
Well, it's leading to the path where you're going to take me to the specifics today, but it's
I'm getting
indicative
closer.
it's indicative of a colourful life, Mr. Murphy.
Well,
in an interesting way.
it's always been very conservative. I've always worked 7 days a week and saved my pennies. But for 2 years this happened. So I won't bore you with the details.
No,
but
I see.
myself and Tummy went to Fiji for the weekend to catch up with Commodore Marama. And while all this conflict was going on, I'd sold a property and I had $2 million in the bank, and I was able to afford to do these things and see a side of the world that I had not seen before. And I didn't think that I was doing anything illegal. We weren't conspiring in any way. We were probably having a bit of a giggle. Tummy was taking youth to Tuhoe and trying to straighten them up, etc., and doing what I could only see was good. I could only see goodness. There was no threats of killing and murder or whatnot. Well, we came back, and then of course everybody got raided and everybody got taken, and it was made headlines across the world, etc., etc. I felt that because I didn't comply with the police and the government, I refused to discuss with them, and I didn't know what angle that they were on, and then all of a sudden people were saying all these horrible things that these people were going to do. And I believe that was started by Paul Dale and Michael Foley by informing to a very low-ranking police officer who'd been a policeman for many years, who was exaggerating to his peer officers what, exactly what they were doing, etc. So I then had to take on the legal system by myself. I had to go to the High Court and use convicted child sex offender Ashley Palmer to help me in my legal things, because there was really no officer of the High Court that I could trust. And I soon learned that the legal profession is something that, although I was brought up to trust lawyers and judges and so forth, I soon found it to be a bit untrustworthy, so I had to play the game. So I learnt what an officer of the High Court was. I learnt what a lawyer's obligations were, that their obligations were first and foremost to the court, to justice, to make sure that justice was done. Then I began to see with respect, I began to see a very close group of people in our legal system in Auckland that would go to the Auckland party, that would talk about the Christmas parties that they'll go to, etc., etc. And so-and-so would tell me, he's a good mate of mine, and blah, 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 well, he knows that judge, etc. So I wasn't beginning to see transparency in our justice system, and I wasn't really seeing transparency in the way that the justice system was looking after Maori. So I became against the system to agree. And then I did find that I'd meet judges such as Judge Bozier, and I'd meet Michelle Kidd down in the courtroom, and I'd meet some judges that were actually decent people that would have a social conscience and weren't there to look after their so-called well-heeled friends. So I then thought, well, if a lawyer's going to say something for you, being an officer of the High Court, and he's got to make sure he does everything properly, that he should not have a conflict of interest. There should be no conflict of interest. And, with Mr. Dale, I went to all the things about conflict of interest to the point where he was sending me a bill one day for his services to represent me personally on the DISMISSAL.
Mr. Murphy, I'm going to direct you back a bit here.
Yes.
Because you've laid a framework which is helpful for me to get an insight into where you're coming from in broader terms. And you've done that well. I understand you put some blocks in there. I don't want, for obvious reasons, to get into a lot of discussion about other lawyers who are not peripheral to this.
Can I now?
It's a bit like if somebody came in here on a case and they started talking about, well, Mr. Murphy, who I know, XYZ, I'd shut that down immediately and I'd say, I'm not hearing criticisms of Mr. Murphy. He's not here, he's not in this case, it's not about him. But that's helpful. It's taken me to give you an understanding of the things that are driving you along. So it's probably helpful at this point to bring to get you to bring me up to this particular issue that concerns you about this particular case, and take me through in particular what your concerns are about the committee's decision, because as I explained at the start, that's what we're here. That's what I want to make sure that you tell me fully about today. And that stuff you've told me is helpful. I've got a sense of a framework from where you're coming. You're saying to me, and excuse me for paraphrasing, but that's what I have to do. But you're saying to me, you've had a bit of a rough time with lawyers that you've been associated with over a period of time. You've lost a bit of trust and faith in them. You had a sound. I don't know the details, of course, but it sounds like a horrific business bust-up. And trust me, from working in those areas over many years in previous jobs, bust-ups and partnerships can be just terrible for people. And so from that, you've had a rather unhappy association with certain members of the law profession. You haven't become so embittered to the point that you think all of them are no good, as you met some ones that you've had.
Good justice. There's good justice.
Yeah, but you've had this sort of unhappy experience. So it's helpful for putting the context for me. Now, what I'd like you to do now is to bring me up to this is and I've read your file through very carefully. I've read all the information on the file. It is a pretty simple, straightforward matter. And I want you to tell me your side of it, and then I want to take you through what I think about it, so that you have benefit of having what the views that I've formed from looking at it, and anything I may wish to ask you about it.
I look at it from the Webster Malcolm case. I'll keep it very simple for you, because otherwise it will get too complicated for both of us. I received this letter. In essence, it said that the brakes had failed on the vehicle. I wasn't allowed, at this point, I wasn't allowed to view the vehicle and check out to see if the brakes had actually failed on the car. With a solicitor, I have learned, and you can correct me if you like, because there's so much wiggle room in it. But he's an officer of the High Court. When a human being goes to a lawyer, they're normally distressed, and they're normally really wanting to go at the other person that they're suing. So, as an officer of the High Court, he takes instructions from his client, but his instructions must be, and have to be, authenticated by him.
Well, let me just touch on that. Let me talk to you about that, because that's really sort of at the nub of what you're saying to us. You're saying they have to be authenticated. Now, well, before I jump in, what would you say would be the authentication that had to happen when a lawyer's client is sitting in front of them?
I would say to you, Mr. Chair, that it's a serious matter because it involves a lot of money. It's a business transaction that's gone sour. If he's to put something on paper, for instance, in my business, we have statutory obligations and we have window cards that we have to put in our cars, fuel efficiency labels. We must ensure that the information that's on those documents is 100% correct.
I understand that, but
And if it's not-
my understanding of your business, Mr. Murphy, would be, and it's something that I have a considerable degree of sympathy with.
Yes.
Car dealers have a reputation amongst the general public akin to lawyers. But I think it must be, my view of that is this, that car dealers every day of the week will be dealing with people who come along and tell them, this car is this, and it's that, and it's this, and it's had a wonderful this, and my elderly granny drove it for 40 years, and the car dealer can't remotely authenticate every story that's told to them. They can't guarantee everything. They have to have a degree, in general commerce, they have to have a degree of faith and trust in what they're told. And I'm not saying this because you're a car dealer, but I have a considerable degree of sympathy for people dealing with the general public who are being told things and then being asked to rely on them. Because whilst, as we all know, you've been in business for many years, you would know this better than anyone, whilst a large number of people will be truthful or slightly truthful, or there's a small percentage there that regrettably aren't. But let me just bring it back to you with respect to a lawyer. And let me explain this to you as a general, just to try and sort of explain this particular complaint and to give you an indication of where I think your difficulties are with this particular complaint. And let me say one thing before I go down this path. Lawyers, every day of the week, have to place reliance on what they're told. Mrs. Smith comes into a lawyer's office and she says, I've been punched by my husband. I've been pushed against the sofa and I've been abused from morning to night. And the lawyer says, well, what do you have any evidence of this? Or no, he's very smart. He only shouts at me when the neighbours are away. He only does this when his parents are there. He's all very nice. But as soon as he's out the door, but I risk for my life. Now what happens then is the lawyer, as his obligations are, you're quite correct, duty to the court, facilitate the administration of justice, duty to their client. Those are at the cornerstone. The lawyer's duty, draft an affidavit. And it says, my client says that, pushed against the sofa, abused so-and-so, 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 so-and-so. Now, it goes to a hearing. There's cross-examination. Gaps appear in this particular framework of recollection of events. After cross-examination, gaps are exposed. A finding is made that the application is dismissed. Is the lawyer guilty of any professional breach or failing? The failing in the case is the failing of the client to tell the lawyer the truth. When Mr. Murphy is told by his customer that this vehicle has this, and I put those on and it had a so-and-so, so-and-so, to the extent that Mr. Murphy can check something, but not everything he can check, Mr. Murphy relies on it. Is he let down occasionally? Regrettably, sadly, and I think probably you'll be able to tell me, but I think probably sadly in your area, often. Now in this case, Mr. Stewart took instructions from a client who said the brakes failed. Now, you've got a reasonable point about The lawyer's not just to sit on his backside and say the brakes failed and blah, 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 blah. But the lawyer also doesn't have a toolkit in his bag that he can race out and check this or check that, or the time to do this or the resource to do it or what. Fundamentally, you rely on your client. What Mr. Stewart does is he drafts a letter to his client and he says in it, make sure what you tell me here is accurate. And the fellow comes back and says, it is. And then he sends it off. Now, the question as to whether you would have a serious argument to find anywhere that there's a serious argument about breaching obligations in circumstances when taking instructions. One thing about your case, I'm reading your file carefully, that, and I have to be very cautious of this, because in my role, I'm not giving evidence on the matter, but from an experience of having taken instructions over years in different circumstances, reading through this particular case, and I don't profess to have the mechanical knowledge that you would have for a moment, but the complaint of failing of brakes was one for me that I would expect a layperson to be able to explain to their lawyer. And it is one which I would have expected a lawyer to be able to rely on. It's not something like, well, the piston and the valves went and the rings were this and they were scorched here, and you're getting into this sort of stuff. The brakes failed. Now, you, Mr. Murphy, were right. You were absolutely correct. You hadn't sold a vehicle with brakes that failed. And I suspect you were probably offended by the thought that you'd sold something, because that's quite a risky sort of a thing. Now, if it had been other sort of minor thing that you didn't know about, well, that's just, you're going to get that all the time. That's life. But I suspect you probably took that and got a bit offended by it. But a lawyer taking instructions from a client, I had an accident, I hit the brakes, they failed. A lawyer is entitled to write that down, to rely on their client, and to have an expectation that they're telling me the truth. The lawyer can't remotely double check every facet, aspect of instructions that are received. But in this case, and I found it interesting, the motor vehicle dealer's decision, there were problems with the car, but that wasn't your big concern. Your concern was this thing about the brakes. The motor vehicle dealer's decision, you will have read it carefully, but it seems to me to be saying, and I don't, please be assured, I don't want to be discourteous to Mr. Stewart's client, he's not here to defend himself, but I can speak to the decision, which is a public record. But it seems to me that Mr. Stewart's client changed his story, found a different excuse, tailored another problem with the car to provide explanation for the brakes. Now, that was a huge jump, and picked up by the adjudicator and commented on. And please, my memory may stand corrected, but I think he described Mr. X, I'll call him, in my decision. I think he described his evidence as malleable. That means changing. Now, you were within your rights to say, no, I didn't sell an unsafe car with unsafe brakes. I found it preposterous that a vehicle could be driven 500 k's when you've got to brake several times every kilometre without a manifest problem appearing. And I don't accept for one moment that this accident was... You were right to hold your position. Mr. Stewart's job as a lawyer, I understand you tell me the background of your general concern, but Mr. Stewart did what a lawyer is. The rules impose obligation on a lawyer to follow their client's instructions. There are countless occasions where lawyers say, you should do this. My instructions are to do that. I'm cautioning you. You should do this. You're to do this. And there are cases where lawyers have been disciplined for not following their client's instructions when they've got notes on their files saying, I told him not to do this. He insisted that these were his instructions and I was to follow them. So in your case, Mr. Stewart, he had a complaint about brake failure. He wrote a letter to his client. He had the report from the garage about other sort of complaints. So it was within a context of mechanical complaints being raised. And he checked it with his client. And then I don't wish to put it, but it seems to me that his client's explanation was subsequently found to be less than convincing. But my question to you would be, you have to persuade me today, if you're going to succeed in this application, that Mr. Stewart's conduct as a lawyer in those circumstances is sufficient to meet a threshold to say that he had committed some breach. And Mr. Murphy, you've been courteous with me today and I think direct and honest in the way you put your position to me, and I'm going to return the favour to you. That's the problem. And I think I can see from you're a support person who seems to be nodding at the,
Following.
nodding at the. It gives me an impression that he seems to be appreciating the argument well.
Mm-hmm.
That's the sort of parameters of the argument.
Thank you, Mr. Chair. My reply would be that I've been dealing in cars since I was 15. I've been in Green Lane that whole time. I'm 56 years of age now. I've sold around 13,800 of them. And we find that I've been through all the changes. In 1993, I had Sales of Goods Act, I had the Motor Vehicle Dealers Act, I had 1993, Consumer Guarantees Act repealed in 2011. I'm aware of our obligations on the car yard, I'm aware of the statements that we make to people, and I'm aware of the consumer. And I appreciate that what you say, that if we do get people come in and, sort of think to ourselves, well, yeah, Little Wee Riding Hood's for real. But we don't comment, we don't argue with them over that, we just deal with what we've got. Now, if I buy a car from somebody and they tell me that it's not what it is, well, it's for me to make that decision on it. Knowingly that if I make the wrong decision and I'm proved wrong afterwards, that the arbitrational body that we've got set up, which is very good and very functional, they've got a job to do and they do turn over. I can go before them and the chances of success there are highly unlikely unless you've got an absolute watertight case. So when we start our process from the beginning, we make sure that we comply in every aspect. That if we do
well, you probably have a good knowledge of how that system works.
Very good. I've read every decision that comes out.
And you probably, and it's astute business it's a necessary part of your business to understand how that works at the end, so that you've got your ducks lined up in the event that you sort of, and in your business it's not, I guess it's inevitably the case that,
And I've learned too, Mr Chair, that if you've got these, for instance, we've got car checks and car jams and motor web supplied by the government that we can check information against the car, they can be wrong. Now, if they are wrong, it's still our problem. There's no guarantee they won't help us, so we have to be very professional in our approach. To the point when, if you look at this Bentley deal, we had changed the mileage on the window card before the chap even drove it out the driveway. Otherwise, Mr Brett Carter will say that's a complaint to the Commerce Commission, because it's done 100 k's since he bought the car, whether you're getting the Warner fitness update, getting it groomed and getting the small bits and things done. In this case, we had total disclosure with this chap. I dealt with him towards the end. It was a car that an expensive Bentley that has high cost of repair. So I took over and I went through and I explained every single defect on the car with the gentleman. It was priced that well that it was going to sell in the next 48 hours. So we didn't want to sell it to somebody. In this case, I read through the file. He hadn't told us, but he'd made an inspection at Gould Traps to inspect the car after he bought it. This is how he thought. So he was going to go up there and get another shopping list to bring back to me. He just thought that he might be able to have a win. He's a guy that speaks with a forked tongue, but I understand that.
But isn't you putting your finger on that? And I don't want to use those words, of course, but I don't understand from your position. And isn't that? And you will have picked from how I like to be careful, of course, but how I put this to you earlier on, that the decision delivered is very clear. And your impression of the reliability of this particular customer on certain things is borne out by the decision. So your assessment was bang on, but
that decision is under appeal.
We have to. All that's before us at the moment is that.
Fair enough.
I can't take that any further. But to the extent that that decision assists with this case, it goes right to the point of the adjudicator in the Motor Vehicle Dealers Disputes Tribunal saying that, and it's quite strongly worded for an adjudicator, saying that he found the evidence on the brakes to be unreliable, but importantly, he found that evidence to have changed. It started off as being this, and then it became that. But we return, and in terms of you helpfully fleshing out how these issues that you have to deal with when looking at credibility and working out what had happened on this particular case. But where you are now is you're in a forum dealing with, the fellow goes off to his lawyer and he's telling the lawyer a particular story. You've established that this fellow has gone off and done other things. He's gone to the disputes tribunal and found that his evidence here is a little bit. But when he sits in front of the lawyer, sits there with his pen, his obligation, take the instructions, get them as carefully as he can, write them down, check them with the client, is this what you say? And then you send them. Now, of course, if they're wrong, and lawyers will issue on any given day of the week hundreds of letters that are disputed, contested, challenged. That is the very nature of the business that they're in. So where you've got to take me to is, where is this lawyer? And bearing in mind, a disciplinary breach is a serious matter. It's got a threshold, a legal threshold that it has to meet.
I'm not after blood here, Mr Chair. But when I receive a letter like this without prejudice on it is, on a very serious matter relating to safety, and then...
I understand that.
But this is what really annoyed me. This is what really annoyed me. In my response to this chap, I said, and he's a family friend evidently, been told me, but my response to him was this: fine, let's look at the car. That's my right under the Consumer Guarantees Act. Let's look at the car. Let's see how, you know, a brake's failing on a Bentley after I've just sold it, after it's just been complied, after I've just done the brakes on the car, part of that compliance about a year before. We had just got a warrant of fitness on the car within the 28
Well, the point being, Mr. Murphy,
frame.
you were right.
I'd done everything right.
Yes.
But then to write salt into sore wounds, and without prejudice letter, I learned all about those over the years, and then not allowed to look at the car. But he wanted me to pay him $3,287 for his finance, his instalments to state insurance, and his legal costs. I believe $5,612.
Mr. Murphy, I see letters.
Without having to look at the car.
Mr. Murphy, I see letters with his demand for 1.8 million, 2.75 million.
Yeah.
You know, and then the letter that comes back is, this is an absolute nonsense and blah, blah, blah. But I understand that.
But I wasn't allowed to look at the vehicle, you know, bring it back in. The first, our number one rule on the Consumer Guarantees Act is, if somebody rings up, they said, we bought this car 4 years ago, we've done 200,000 Ks in the car and the transmission's blown up. What are you going to do about it? I'll run citizens' advice and they're saying, you've got to fix it. How unreasonable is that? Not a problem. Could you kindly bring the car back? So we can do our own assessment. Otherwise, we end up in front of this tribunal and they'll go, well, it does a big circle, okay? Now, this chap, without prejudice, he just, and we've got it in the 3 or 4 times, no, you can't have the car back until you pay. Well, he should have known better. I'm not after a witch hunt. I know that you've got to protect the profession, and this chap is now a judge in Fiji. And so I've got to be able to put my point across. I run a commercial enterprise employing 6 people in very difficult times, okay? And we're beginning to see a little bit of light at the end of the tunnel through hard work. Dealing with these things, you know, I've got another...
I understand. Mr. Murphy, let me just explain one thing I am going to clarify for you.
Right.
And it's your concern about, and I hear what you say, this thing about the legal profession, protecting the profession, that type of thing. This office is an office of review.
Right.
Standards committees who make the initial decision are comprised of lawyers and a couple of lay people, to give a lay person. They produce the decision. Review officers are independent. They consistently over the years, review officers will turn over, change or modify around 1 or 2 decisions in 10. That's what would be expected in any appellate review type process. You would expect committees to get a fair, reasonable answer most of the time, but on occasions this office will overturn it. But to return to what I want when you walk out today is 2 things: to make sure that you feel that you've had your say and been listened to, and secondly, that the issue that I think is at the nub and crutch of, rather than write a decision to you that comes out in the mail and I prefer to tell you here and now, this is where I think your difficulties are with this particular complaint. But what I am, and I've identified those for you, but what I am able to say to you is that reading through the file in its totality, I got a fair and reasonable view of why Mr. Murphy would be upset at this.
Thank you, Mr. Chair.
And it seemed to me to be entirely reasonable when Mr. Murphy had done work on this car, He knew the work that had been done. When a buyer takes a car and travels 500k, when the buyer has a minor crash, which seemed to me to be related to him looking at lights flashing on a panel, totally unrelated to his brakes, but then the process inevitably has to work down until you finally get to the nub of it. So I quite understood Mr. Murphy's sense of dissatisfaction with that. But this office is about legal conduct. And I also understand that you saw the lawyer, and you helpfully, by backgrounding at the start, your previous sort of experiences, provide the sort of useful context to it. But all I'm asking, all I'm saying to you is, when I step it back, when I look at what the lawyer's obligations are, when I look at the high threshold for deceptive or dishonest behaviour and those sorts of things, there may have been dishonest and deceptive behaviour here, but it's a bit like if a dishonest and deceptive client tells you something, Mr. Murphy, that you then rely on.
I don't have an insurance bonding system that I have to belong to in case somebody does tell me a lie. I can't fall back on an insurance company or an underwriter and put them on notice to say that we've got a claim against the company. I've got to deal with it myself, and I tell you, I'm getting a bit over it, at the moment. In the High Court on one, and the tribunal do their best, but they've got to turn them over, and I do feel so. I get so angry with them, frustrated.
I understand.
But they've got a job to do. They've got to.
Mr. Murphy, do you feel that you've had your position put here today?
One thing I'd like to clarify,
Yeah.
and I must thank you for being courteous, and I sort of predict the outcome, but I would like to, this is my point. Webster Malcolm should have allowed us, before they wrote us this letter, to have access to the vehicle to check it out. It's not without prejudice, and they didn't allow us to do that. To say that the brakes did not fail when there was information on their desk to say that they didn't, I find to be a little bit of a concern also, because all this is here from Bing, he asked for that and he received it. So, they were trying. And they were just, if you were new in business, and I can assure you, Mr. Chair, if you got that on your desk on a Monday morning, you'd be going, wow.
Yes.
So getting a letter on the divorce court from Tony
I do not, yes, and I think lawyers are sometimes oblivious to that.
Yeah.
But I keep coming back, Mr. Murphy, to this point.
Then I've got to employ a child sex offender to help me out. That's only that good because he got out of jail for preventative detention, because I've got no faith in the legal system. And I'm currently using another one at the moment who's in jail for a heinous crime, but because he's been in there for 31 years, he's learned the law backwards. Okay, and he's not an officer of the High Court. I'm frustrated, I really am.
Yeah, I understand.
And I should be able to rely, and Sir Carruthers has rung me, he's well aware of who I deal with in these situations, and I should be able to, when I saw this, I thought, well, it's not without prejudice, and then we said, well, bring it in, please, doing the right thing. Bearing in mind the chap had been in after he'd crashed the car and told me he loved it, he wanted to keep it, but then guess what, the insurance company failed, so we're all like, so I don't know, he's got insurance that covers it. I don't want a penny from this man. I just want it to be noted that he's acted more for his wallet, I believe, than what he has for justice, because the brakes didn't fail. Look at this, it's just nonsense. And
let me just take you back, before you
get Section 8 of the Consumer Guarantee said, well, I know the act, bring it back, let's have a look at the car. And he's wrong. It went on for 6 months before we were able to look at the thing. Guess what we found then? And then he lied to the tribunal. If you read the report, the Westlake report, to get a child sex offender to go and inspect the vehicle to find out that they were wrong, that they were telling untruths in affidavit. Is that justice?
Mr. Murphy, let me hold to you for a moment. Mr. King,
yes.
I'm just going to, and on occasions I'll do this, rare occasions, But you've been here assisting Mr. Murphy, and thank you for that.
That's all right.
And I think it's often good for people to have somebody. I'm very supportive of that.
Mm-hmm.
As Mr. Murphy's sidekick today, have you understood the issues as they've been traversed and run through?
To put simply, I would say that it would be for John to prove that the lawyer had done something in some sort of dishonest way, and that he's acting on instruction. And it's, if I could put it simply, if John went and told one of his employees to do something and his employee did something wrong, it's not for the employee that was just acting on instruction.
My point, the question for you is, you've understood, you've heard the process.
Yes,
and
I
you feel
totally
Mr.
get where you're
Murphy
coming from.
Has
Yes.
given me a good sort of exposition of his position.
Yes, yes.
Mr. Murphy, is there anything further you wish to add?
Mr. Chair, I'm just frustrated with the whole, from the day I got this letter, this without prejudice letter, to not be able to have the car returned, to the fact that this particular lawyer knew that the brakes didn't fail because he had that information in front of him.
What information do you say?
He had the Gill Track report.
Yes, which was silent as to the brakes. Yes.
Which it was a report to find out defects on the car. Now, it was, and we've been up and seen Gill Tracks, and they were very impartial. And their words were that it isn't a bad old thing, you know. And I just thought, well, he mentions in here, up to the concern around his Atkins letter under Section 18 and others, but with my experience over the years, and I've had some real bun fights, I can assure you, over motor vehicles, because they do get very emotional, is that the first rule on the CTA is that you must give the retailer the right to rectify the problem. Now, to do that, they've got to return the vehicle. Now, we can get the car back at that point and say, listen, there's nothing the matter with the brakes, Mr. Bean, go away. We'll fix these other issues for you and we'll see you later. Don't tell porkies. Because, you know, like you rightly said, we get told a whole lot of fairy tales. And if we were to put claims on everybody that we bought a car off, I'd be sitting in the district court all week. So you better just, right you are, that's a bit of puffery. And we should know better because we're registered motor vehicle traders. Now, I know you don't want to hear this, Mr. Chair, but this chap's got a judicial duty to his client, to justice and to me. Because if he had bullied me in, and I've seen some real standover letters from lawyers over the years, I can assure you. I won't name them, but they come across very intimidating to the average person. This letter turns up. I sort of expected it coming because the finance company had rung me a few months earlier while they ran around looking for ammunition, and they'd said, the finance now had rung me and said, oh, he's going to court and he's going to get his money back. So I dutifully just waited and waited. And if you go through the complete file from Mr. Webster Malcolm, he says here, you better move quick, Mr. Bean, because time's running out. You've got to work out whether you want to do the insurance company, the car dealer, or whoever else you want to blame. And we're generally the one, they always say they always blame the car dealer and they always blame the cleaners. So we're ready for these situations that do turn up. So we have to be conversant with legislation that's made by Parliament. And it was our right to get the car back. Now, he's preaching to me sections of the Consumer Guarantees Act. I was without prejudice letter. And just trying to bully me into taking the car back, paying the payments and getting a crashed car back into my car yard. And they go along to the tribunal and they told Porky...
Well, the sort of reply to that too, Mr. Murphy, is that lawyers and I come back. Lawyers are required to file their instructions, and you say there's nothing in this letter, and all the rest of it. The response to that is, you as the recipient of the letter are able, as is any recipient of any lawyer's letter, to consign it to the bin. You're able you have your experience, your background, your knowledge that you're able to draw on. You're able to identify things that you think, that won't stand up, that is just part and parcel for literally hundreds of demands, letters sent every day. Parties on the other side, some of the demands will have an unequivocally clear case. Some of them will have contestable parts of the case and others that aren't contestable. Some of them will be an abject failure in trying to advance a case. But you were well equipped in this particular case to both A, have the experience to understand it, B, know the law, C, understand what the process was. You were no novice on the block.
And I'm no officer of the High Court either, Mr. Chair.
I
I'm
appreciate
no
that.
officer of the High Court, and he is. And that's the difference. I schools and failed twice. I started in business at 16, and unfortunately the industry we're in, we are under attack. And I've been through my distaste of the legal profession. You know, my sister was a Crown prosecutor. We come from a family that has got a legal background, and we certainly don't discuss any of my affairs. Now, this here, in my view, from my experience, if it comes through without prejudice, etc., bring the car back. And he kept saying to us, no, 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 no. And then he's got to be held responsible for the allegations that he's made. He's got insurance against his client from telling him porkies. His client certainly gave me the indication that it was a very close law that they used. You know, we have to deal with finance now. They're a finance obligation that we deal with, and it put tarnish on my business for future finance too, to say that we weren't going to give the money back on this car. When he was telling them conflicting stories, like Webster Malcolm had sent them the letter. And, you know, if finance now had pulled our facility, that would have put a great deal of stress on my business. It would have meant that we would have had to get a second-tier finance companies to use, and finance now is an important income stream for my companies. So I had to deal with finance now, their legal department. They took it very seriously.
Mr. Murphy, who's appealed the motor vehicle dealers?
I've appealed
You've
it.
appealed.
I've appealed it, and I've appealed it, and I've got a judicial review on it at the moment also, Mr. Chair, on another decision from the tribunal, where the consumer has misled the tribunal. You know, the tribunal instructed by the minister to turn these things over. There's two of them there. They've got 360 cases.
When is your appeal likely to be heard?
It went to appeal in front of Judge Harrison. He unfortunately got ill.
So it's in the pipeline.
We've had 5 hearings already. And Mr. Bing we tried to settle, he got a new lawyer, this Webster Malcolm, he got a new lawyer at the last hearing. I've responded a memo today to the district court.
All right, no, I shouldn't get you to take me.
But it will probably go, because the district court is so obliged to stick by the decision of the tribunal that they'll end up in a judicial review. And that's where this will ultimately head up, and it's like jumping through loops. So if I have to do it properly, blow it. Webster Malcolm should be held to account for this, because it's not as if it just finished with this letter making this allegation. Do you understand, Mr. Chair? I know you're doing your best.
Mr. Murphy, you've taken me through your position this morning courteously.
Thank you so much.
And I thank you for that.
Yep.
You've explained the background helpfully. I have endeavoured, as I say, rather than get a scribbly thing in the mail out to you later on, I've endeavoured face to face with you today to tell you the areas where I think...
Where do you think I'm in trouble?
Where I think that your case has difficulty,
yes,
is, and I'm retraversing what I've touched over earlier,
right.
but In your other jurisdictions, of course, when you're talking about the High Court, the motor vehicle dealers, you're in a particular civil jurisdiction. In this jurisdiction, you're dealing with a disciplinary, you're dealing with a conduct jurisdiction.
Right.
You're dealing with a jurisdiction which is governed by conduct rules, which is governed by the Act, which is governed by, you know, a raft of interrelating things. Any party who seeks to bring a conduct complaint against a lawyer, their evidence has to meet a certain threshold, and that would be the same in any jurisdiction. You just can't, when there is, irrespective of what people might think about car dealers or whatever, they can't just go out and say Mr. Murphy's a crook, Mr. Murphy's a fraud, Mr. Murphy's a this, Mr. Murphy's a that. You can't do that. In a disciplinary jurisdiction where it's issues of professional reputation, it's important matters of reputation for people, evidence has to meet a threshold. But I come back to the steps I took you through right at the beginning. Here, a lawyer gets instructions from his client. His client tells him what happened. And what your argument is, and I totally understand it, the law says, the rules say, a lawyer must follow their client's instructions. A lawyer can be in breach if they fail to do so. You correctly point to those higher obligations owed by a lawyer as well, as duty as an officer of the court, duty to facilitate and administer the justice, those sorts of things. So under the sort of pinning that is a sort of veiled suggestion that Mr. Stewart has been in some way deceptive or dishonest. That's how you have to get to that threshold of you see what I mean? Now, just bear with me for a second. Be patient. You asked me to explain it to you, and I'm endeavouring to do that. And I know you say, well, we should have got the car back. Well, that actually wasn't part of the complaint. I'm not really focused on that. Well, this should have happened. You should have realised this was this. But if you impose this sort of level of obligation on lawyers, and the obligation, for example, there are many cases, and I've dealt with them myself, where parties have sworn affidavits before the court and then they've blamed the lawyer for the affidavit. And judges have said, this is the client's affidavit. It is not the lawyer saying that this happened on such and 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 such. It's the client. And if a client doesn't tell Mr. Stewart the full story, in a busy office, taking instructions, relying on your client, putting faith in what they say, you are their advocate. You have to, if Mr. Murphy goes to his lawyer, and Mr. Murphy, let's say I'm Mr. Murphy's lawyer, Mr. Murphy comes and says to me, A, B, C, D, E, and I say, well, that's not right. No, that can't be right. I don't believe you. And Mr. Murphy says, well, it did happen. And I say, well, I'm not going to write that. I don't believe it. Mr. Murphy says, well, the brakes failed. I know what happens when brakes fail, says Mr. Murphy. I pumped the brake. It didn't work. Well, I, as Mr. Murphy might say, oh, okay, you clear on that? Are you sure about that? Are those your instructions? The issue is Mr. Stewart being deceptive, misleading, dishonest? Any of those serious things that require a high standard of proof to bring him into a point of behaving in an unconscionable way, such as to merit a disciplinary finding on his record by taking instructions from Mr. Bing, getting a report which says the car was damaged in certain ways. Now, Mr. Murphy, I'll profess my ignorance openly to you. I read through that report. I don't know if those things would affect brakes or had input, particularly if cars today, leads might have, pressure points might have, computers might have. I just don't know. As a lawyer, sitting in the office with my client, I'd rely on, he said to me, I put the foot on the brake, it didn't work, the brakes failed, I couldn't stop the car. And then I would make sure that I said to my client, well, this is what you say. A, B, C, D, E. And Mr. Murphy sends a letter out to his client and he says, this is what you say. You must be sure that you're accurate here. He says that. Is this what happened? Now, his client says yes, and I'm in Mr. Murphy's court when it goes further down the track.
Mr. Chair, one thing that...
Just bear with me for
yes,
2 more minutes.
Thank you.
And then I'm be assured, you're going to... That's where you're coming in and saying, Mr. Murphy should have done more, or at its worst, you're saying he was dishonest. Now, the Standards Committee, the lay people who've looked at it say they don't believe that remotely gets near to proving that. So that's the area today in front of me, is the kernel of the issue, if you like.
Just 2 points, Mr. Chair. When Mr. Palmer was alive, he did have a very good grasp of the law and he was very, very focused on this issue. What he did make quite clear to me was, when we discovered that Mr. Bing had told or instructed Webster Malcolm that the brakes didn't fail, that it was in fact an issue. Bearing in mind he continued on with the Westlake report where they lied there too, and Webster Malcolm was still acting. Webster Malcolm should have just pulled out. They should have just closed the account and moved on, but they continued to take his money. The other point is that as far as the tribunal goes, Mr. Stewart was using his influence and power and he was talking to the tribunal.
I can't touch on that.
I know it's on the complaint, but let's just deal with...
Yeah, but I mean, no, in fairness, if this was something involving Mr. Murphy today and someone was bringing something totally in that Mr. Murphy hadn't had a chance to, I'd be shutting it down. It wouldn't be fair to you.
Webster Malcolm today continues to act and they're acting upon it.
I thought you said Mr. Bing had another lawyer.
Well, the chap, Alan Stewart, I believe, is now practicing as a judge in Fiji, in that jurisdiction. But you know, at that point when it was true that there was some untruth made or instructions taken, etc., on or without prejudice letter, he continued to act, and I still believe that he's acting today in the district court on the appeal. I know what you're saying, but he's not Lily White, Mr. Chair. He's not coming to court with clean hands. And I will respect your decision, and I know where it's going, and I understand that because reading the decisions, it seems to be that you've got to steal money out of trust accounts to criticise this jurisdiction. So I'll leave it at that. Thank you very much for being such a lovely man, such a lovely human being.
It's been a pleasure.
And Jan being so kind to me over the years for being such a good punching bag. And I'll leave you to it and I'll just respect your decision, mate.
Mr. Murphy.
I have been angry with the justice system, Mr. Chair. I really have been frustrated with it.
Mr. Murphy, I perceived that, I understood that, that's been self-evident before I walked in the door here today.
But it's not all bad.
But I will reiterate to
it's not all
you,
bad.
you have been courteous today.
Yes.
You have been, you've explained your position well.
Yes.
You've got a bit passionate about matters that are important to you. You provided a helpful background at the start. I could have shut that down, but you actually provided a helpful background to explain some of the degrees of frustrations with you, with getting to where you are. I simply hope that from my perspective, I've been able, although you'll buttress your head up against the points you disagree with, of course, and I wouldn't expect any less, but I hope that in some way I've been able to explain to you today about the specifics of this complaint, the issues that I have to deal with legally, and the steps that I have to examine in the legal context in this jurisdiction with this matter. So I hope that you leave at least with a partial...
I'll respect your decision. I kind of know what it's going to be, but that's okay. That's the way that, you can't,
Well,
I fought the law and the law won, I guess.
I've taken the step today of giving you an indication. I'm not giving you a conclusion, but I've given you an indication because for a simple reason that on some occasions it's a more direct and it's a more straightforward way to deal with people face to face and give them your views. And in courts over many years, I've seen judges that will give a decision 6 weeks later and it's posted out to people, and many times, of course, that has to happen with reflection, court and care and all the rest of it. And then some judges who are able on the day to be able to say to people, look, this is the view I've formed and I'm going to tell you now. You deserve to know what I'm thinking and the reasons for it and the explanations for it. But Mr. Murphy, thank you for that. Mr. Keane, you've been a particularly helpful support person for Mr. Murphy today, and thank you for coming along.
Thank you, Mr. Chair.
Thank you, Mr. Chair.
All right, I'll be here for a few minutes, so
Good
free
as.
to go. Thank you.
Thanks, Jen.
You have a pleasant rest of your week. The crux of the matter is...
Nice about it,
Yeah, the crux of the matter
He knows
is...
it's going to be good today.
He knows that the... I'll just go for it. Crux of the matter is that him continuing on writing that letter after seeing the Gill Track report, but he was still following instruction.
That's right.
And he's not doing anything personally.
No,
Yeah.
it's just wrong, eh?
Do you get what I mean?
Imagine if we'd done that, mate.
Oh, yeah, I agree.
But anyway, he's got a difficult job.